This is Rob McKenna, State Attorney General. Let me turn the podium over to Secretary of State Sam Reed for some background on felon disenfranchisement and whatever else you want to add, Sam, and then I'll frame the legal issues that will be before the court on Tuesday.
Well, I want to first say I'm really pleased to have the strong representation by Attorney General on this significant issue. I appreciate him personally taking this to the Circuit Court, and we really remain optimistic. The courts will uphold our long-standing ban on voting by felons. This has been the policy in Washington since territorial days, and there's a broad consensus in this state and also across America. 47 other states have this policy. 3 other circuit courts have reached the same conclusion that we believe the Ninth Circuit will agree on. If not, I certainly would advocate carrying this up to the Supreme Court. This case out of Spokane and the Walla Walla Penitentiary has been knocking around the court system for 14 years, and we are really left to have some finality here. We believe in the state of Washington very strongly in racial equality. Our Constitution, our laws are very dedicated to that, as well as the people serve in our government. And we have a criminal justice system that is free of bias, and this has been demonstrated in court. We can all agree to work towards those ends, but the question of voting rights is a separate matter, and we don't believe the inmates have proven their case that the disenfranchisement violates the Federal Voting Rights Act of '65. In conclusion, we believe the loss of voting rights is really a reasonable and appropriate sanction for society to demand of felons while they are behind bars or on community supervision. Just I think, very sound public policy.
Thank you, Mr. Secretary. So there are 2 issues that we'll be arguing before the Ninth Circuit Court of Appeals on Tuesday. This is an 11-judge en banc review. It will be led by the Chief Judge of the Ninth Circuit, Chief Judge Kaczynski, and we'll be arguing both of these main issues. The first is that we believe the Voting Rights Act does not apply to felon disenfranchisement. The second is, even if it did, our felon disenfranchisement law doesn't violate the Voting Rights Act, which is exactly the conclusion reached by the district court when it considered the matter a few years ago. First, why the Voting Rights Act doesn't apply to felon disenfranchisement. This is a conclusion that the other circuit courts of appeal which have looked at the question have reached. They have all held in the 1st, 2nd, and 11th circuits that felon disenfranchisement is not reached at all by the Federal Voting Rights Act. They found that Congress did not intend, and still does not intend, the Voting Rights Act to apply to disenfranchisement of convicted felons. Felon disenfranchisement is sanctioned in the 14th Amendment to the United States Constitution. It is the rule of law in 48 states, including Washington State, and as Secretary Reed pointed out, this has been the law of our state since we were a territory, and in fact, disenfranchisement is mandated by our state constitution. Loss of voting rights while incarcerated and on supervision is reasonable, and it's a policy decision for the states to make, not for the courts to interfere with. Issue 2, assuming for the sake of argument that the Voting Rights Act does apply to our state's felon disenfranchisement statute and its application. The plaintiffs in this case point to studies that allege racial discrimination in our state's criminal justice system. It's important to note that several of the studies on which they rely were actually conducted by the state itself in order to address concerns about racial discrimination and to root it out. And that's the first point I want to make. Racial discrimination in the criminal justice system, wherever it's found, should not be tolerated. It ought to be rooted out, and that's exactly why these studies were conducted in the first place, by the state Supreme Court, by the Washington State Patrol, and by academics who they retained. My second point here is that in individual cases where an individual believes that racial discrimination tainted his or her conviction, that should not be tolerated either. And in fact, where racial discrimination is alleged in a specific case, that is a grounds for appeal, and convictions can be overturned in some instances because enough racial discrimination or some racial discrimination is demonstrated. Note that in this case, none of the plaintiffs named in this case allege that their particular convictions were tainted by racial discrimination. Third, the district court did conclude that Washington's criminal justice system is tainted by racial discrimination, but we believe the court improperly extrapolated from this handful of studies to draw broad conclusions about our state's entire criminal justice system. So we disagree with the district court. But we do agree with the district court when it found that examining all of the circumstances surrounding voting by communities of color in our state, the Washington state does not violate the Voting Rights Act, and the fact of some alleged racial discrimination in the criminal justice system does not satisfy the Voting Rights Act's totality of circumstances test. Unfortunately, the Ninth Circuit panel in its ruling this past January chose to ignore all of the other factors that Congress said you're supposed to apply in any Voting Rights Act case. You're supposed to look at the totality of circumstances surrounding the ability of communities of color and individuals in those communities and their ability to vote. And the Ninth Circuit panel simply didn't do that. They looked at only one of the factors, and like the district court, they improperly extrapolate from these studies to much, much broader conclusions. But as I say, the threshold question is whether the Voting Rights Act even applies to felon disenfranchisement. The other courts of appeal that have looked at this question have ruled conclusively that the VRA does not apply in these cases. We believe that's the right holding, and that's the argument that I'll be making on Tuesday in San Francisco.